Appearances, please.
Daryl Weinman and Rachel Messer here on behalf of, well, really on behalf of ourselves, but we represent John Chris Baker.
He's just appeared. Let me join. So.
Oh, okay.
Are you Jimmy Evans here on behalf of Amanda Baker, the respondent for today's hearing?
All right.
Lara Nixon, guardian ad litem for the children.
Thank you. All right, Ms. Weinman, Ms. Messer, I see this is your motion to withdraw.
Yes, so without getting into any protected communications, attorney-client communications, communication has broken down between attorneys and client that we can no longer work together. So we have filed this motion to withdraw. Mr. Baker has signed it. He's in agreement. Mr. Evans apparently wants some additional language to be added that's not in any pleading or motion. And
I suspect that has to do with the current July 1st setting that has been reset. It was supposed to go to trial on a final in March.
Right. Judge, I've been on this case since 2018, and Mr. Baker has twice before the 2020 trial hired and fired attorneys and used that, at the last minute to get continuances. It happened again in this case back in the March, where he fired that recent attorney and Ms. Weinman was hired. And but for Judge Lytle basically telling everybody, don't even try it. I was asked privately if we would agree to a continuance when they came on board 3 weeks or 2 weeks before this trial that was supposed to happen in March. All I'm asking, because Mr. Baker is a very capable pro se, he knows how to litigate, he's filed multiple motions, I've appeared in many hearings with him. And all I'm asking is that the last sentence, which was uploaded in the other box, is that any new counsel, hiring a new attorney is not a ground for continuance. They take it subject to this date, this trial date, and that in and of itself is not a ground for a continuance. And absent some kind of an emergency beyond everybody's control, that there's not going to be another continuance granted. We've had recommendations from the Guardian since November 4th to implement mental health recommendations that Mr. Baker is supposed to engage in individual counseling and some anti-alienation work. And we tried temporary orders to get them implemented. We tried to get the final trial in March to get them implemented, and he's just actively refusing to do it. I am not opposed to them withdrawing. I've just asked for that last sentence, which they clearly told me Mr. Baker will not agree to, which signals to me that the same pattern may continue. So I'm just asking that we add that last paragraph. I'm not contesting their withdrawal. I'm just trying to protect this July 1st setting as much as possible.
we have never said that Mr. Baker refuses that language. We've said it's not in our pleading, it's not before the court, and we just.
Well, it is before the court that it is May 31st. I think that's a reasonable request, and Mr. Baker, I'll hear from you. This is, I can look at the file and I can see that you didn't go in March of this year when you were supposed to, because you hired a new lawyer. And so, well, this is the second lawyer. And so, well, this is the second lawyer you've had in as many months. So if I'm happy to grant the withdrawal, but the order will state there will be no continuances based on new attorneys getting on board. Either your attorneys can withdraw, and you can hire a new one, but you better get after it. A month is enough for somebody to get up to speed, or you can represent yourself pro se.
You want me to submit an order?
I'm going to give Mr. Baker a chance to respond to that.
Good morning, Your Honor. Thank you. Are we on the record currently? Just curious.
Yes, we are.
Okay, thanks. Wonderful. As of the March hearing, I was adamantly go. We unfortunately were bumped. At that time, Rachel Messner tried to reschedule the final at my request, and Mr. Evans refused to do so and got in the elevator and left. We spent the last few weeks really diligently trying to set that final hearing date, but Mr. Evans would give us no date. So we
have a date now. So what's the problem?
So we insisted on setting. I do not anticipate moving that date in any way, and I wholeheartedly am excited to be there July 1st. So right. I don't want him to add any language that Daryl. I do trust Daryl. If she doesn't want the language added, I don't want it added.
I'm going to add the language. I will grant the continuance, but the order will state, and I'll handwrite it if I need to. There will be no further continuances based on new counsel. Period. End of story. If you're ready to go, and I'm going to make a docket note that says no further continuances should be granted because of you having a new counsel who may or may not be ready.
That would be fine. I respectfully would since we're on the record, add, I feel like that compromises my rights, but I'm happy that you add it because I intend to be there July 1st.
Well, I think the fact that it's not being heard again, the fact that your attorneys are withdrawing, the second set of attorneys to withdraw in just a few months, I think I have to worry about the other side's rights as well. And since we've had recommendations since November, you'll be on your third lawyer if you get a new one, or you'll be pro se for July. I have to balance your rights as well as the other party's rights, and that's how I'm going to do it. So, Ms. Weinman, if you want to send me an order, I will handwrite in there that the hiring of new counsel will not be grounds for a continuance, and I'm going to make a docket note to that effect. So,
And our version of that order is in the box, Judge, or I can email it directly to Ms. Chambers or whatever you prefer.
email it directly to my submission email address, please.
Okay, will do.
Okay. Anything else?
Thank
Mr.
you for accommodating.
You're welcome. Mr. Baker, if you don't get new counsel, you need to be aware of announcement dates, which is the week before the July hearing, Monday, Tuesday, Wednesday, you need to announce. You need to have your pretrial filings filed as well. Proposed disposition of other issues, a budget, etc. Yes.
Can,
Quick question. We filed that for the March 28th. Does that still stand if it's not changed? All the
Sure.
pre-trials.
Yeah. If you want to go forward on those, that's fine.
And Lara, Lara, I believe, is on the call. She has asked that she be able to attend by Zoom. If I'm just putting that out there, we'll file that, but just letting everybody know. Thank you.
I don't
just to advise Mr. Baker, he does need to refile those pretrials so he doesn't miss that deadline. He can use the same ones, but he has to refile them.
And Ms. Nixon, is there a request that you be able to appear remotely? I saw that in some docket notes. I'll make a docket note that I'm granting that request today.
Yeah.
And
Yes, Your Honor. When it got
before you,
used, I needed to.
And just in case, Judge, for the record, we don't have any objection to that.
Okay. Well, just in case another judge does, I'm going to make a docket note that says I've granted that request.
and Judge, but we're going to get to see Mr. Evans' submission to you before you sign it, right? Just to make sure it says limited to what he said.
Mr. Evans, send it to Ms. Wyman first.
Yeah.
Or
Will do.
simultaneously.
Well, why don't you pull it up? Let's all look at it and see what it says and take care of it now.
Because this is the language that we submitted now. It's a little bit broader than what you ordered. So if you want me to edit that.
Yes, please.
Yep. Now, I think you just need to, it is further ordered that no continuance shall be granted, no continuance of the July 1st final hearing shall be granted based on Mr. Baker being unable to obtain new counsel or new counsel not being ready to go. That's not very artful, but.
And in this language, Judge, just any new counsel takes subject to the notice in the hearing. Retaining.
I think you can put a period after retaining new counsel.
Right here, right?
Yep. I do think that's superfluous language. I mean, I think you don't need all the rest of that.
That.
You should also say it is further ordered that the guardian ad litem may appear at the July 1st, 2024 hearing remotely. Does that work, Ms. Wyman? Mr.
Yes.
Baker?
All right. And then I'll email that to Ms. Chambers.
Do you want to sign it, Ms. Wyman?
I don't have to sign it. I just wanted to make sure that I got to look at it. That's fine.
Email it to my submission email address, Mr. Evans, 419.
Okay. And then I'll take off the signatures for attorneys since it's not technically by agreement. All right, will do. And I'll email this and copy Daryl shortly.
Thank you.
Thank you, Your Honor.
Appearances, please.
Thank you.
Excuse. Can you all hear me?
Yes,
Yes,
ma'am. I can hear you.
Again, I'm Taisha Kimbrough. I am counsel for Mr. Gilbert Bowman, who is the respondent in this matter.
Hi, and I'm Sheena Bowman. I'm the mother.
All right, and you all are here on temporary orders that have been announced for an hour. Is that correct?
Yes, ma'am.
Okay, Mr. Bowman, you should let your attorney answer for you. Ms. Bowman will speak, okay? All right, Ms. Kimbrough, I think this is your setting for temporary orders, correct? So you're the movement?
Yes, Your Honor, we are requesting temporary orders in this matter.
All right, let me give Ms. Bowman, here's how this is going to work. I'm going to start by hearing opening statements. Opening statements are not evidence. There were an opportunity for Ms. Kimbrough and then for you to each tell me what relief you want me to grant. In other words, what order do you want me to issue today? After that, I'll swear in witnesses and we'll take hear evidence from the witnesses as well as any documents that might be admitted into evidence. And then after that, everybody will be able to make a brief final order. A brief closing argument. All right, so do you have, Ms. Bowman, do you have any questions about any of that?
No, ma'am.
Okay, Ms. Kimber, do you want to give me a brief opening statement?
Yes, Your Honor, and give me one brief moment if you don't mind. Once we got connected to Zoom, everything on my screen went away. One brief second. Okay, wonderful. We are all well on my end. So, Your Honor, as I mentioned, I'm Taisha Kimbrough, and I am counsel for Mr. Gilbert Bowman, who is the respondent in this matter. In today's situation, the scope of this hearing is limited to possession and access. There is already a Virginia court order that was issued in March of 2024 that addresses the sole issue of child support. Mr. Bowman is a dedicated father who has been unjustly prevented from having access to his 4-year-old child, Skylar. He is here today seeking a fair resolution as illustrated in our proposed disposition of issues. And in our proposal, Mr. Bowman is seeking to serve as a joint managing conservator of their child, Skylar. He is seeking a standard possession order. He is seeking to have rights by agreement, and we're referencing invasive medical decisions, educational decisions, and psychological and psychiatric decisions. He is also requesting that the parties alternate paying for travel expenses between Texas and Virginia. He is also seeking that mom alert him prior to any out-of-country travel. He's further seeking to have electronic communication with his child, Skylar, between the hours of 5 p.m. and 7 p.m. daily. And he is also seeking to be awarded attorney fees for having to pursue this matter.
Is your proposed disposition, is it filed with the court file?
Yes, Your Honor, it is. And it is also an exhibit in box in particular. And if you want me to provide it to you in another manner, I'm happy to do so.
I found it. That's fine. Okay. Thank you. Ms. Bowman.
And Your Honor, one other thing, it is important to note that Ms. Bowman currently resides in the state of Texas, while my client, Mr. Bowman, resides in Virginia. But it is my understanding that Ms. Bowman does intend to move this fall to Virginia.
Ms. Bowman, again, this is opening. You may tell me what relief you want me to grant today.
Yes, ma'am. I am, as his attorney stated, that I am moving back to Virginia this fall. And so I am looking to start out because he haven't seen Skylar since she was 1.5, and she does not know him. So I'm looking to start out with, when I move back, for visitation hours, not me stating that I have to be there, but just start out so that she can get to know him. Maybe 6 hours every other Saturday, or every Saturday if he chooses to. But my goal is for her to get to know him, and then we can then start with, and then after them getting to know each other, then start out and then go with sleepovers. But again, my goal is I want him to be there. I want him to, for them to know each other. But she hasn't seen him since she was 1, and she's about to be 5. And so I just want her to get to know him first before we just up and put her in a situation that she's not familiar with. And so that is my thing. And again, I am moving back this fall. So that's the thing, is I wanted to at least start that process during that time.
Okay.
And I'm moving back so that it doesn't have an effect on her. That was my choice to do so, is to move back, because I don't want to just, put her in a situation that she's not understanding. And so again, that was my choice to move back so that she can get to know him every other weekend or whatever the course decide. Again, I just don't want it to be traumatic for her.
No.
So that is my thing.
I appreciate that. Okay. Ms. Kimbrough, if the evidence shows that, in fact, Dad hadn't seen her since she was 1, I'm not going to just start out at the box with a standard possession order. That makes sense to me, that we'd have to the child would have to be introduced to Dad, if that's in fact the case.
Yes, Your Honor. That is the case where Dad has not had access with his child since she was around 1.5. Is that correct, Mr. Bowman? But as I mentioned, it is his assertion that Mom has been preventing him from having access.
Well,
And
okay, that may be. That may very, and I don't need to get into that. If the facts are that for whatever reason he hasn't seen the child since she's 4.5 now, since she was 1.5, she doesn't know him. And I'm not just going to send a child who doesn't know him for a weekend. So I'm going to do a stair step.
And we understand that, Your Honor, but we have not been able to reach any sort of agreement with Ms. Bowman in order to get this resolved. So we're here today for the court's intervention and assistance with some sort of order that does help us get this resolved.
Okay. Again, I'm happy to hear evidence if you think I need to. I mean, based on that, I could start. Well, go ahead and put on your evidence. I could fashion a stair step schedule, but maybe I need to hear something. Ms. Bowman? Yes, Ms. Bowman.
So his attorney did come to me and asked me, would it be okay if Mr. Bowman come to Texas, get her for a couple of hours on a Saturday and a Sunday? I agreed with her that is great. That would be great for him to come here until I get back to Virginia, and we can then start that process. And she came back and said that Mr. Bowman did not want to do that. So I did agree.
Okay.
Yes, ma'am.
Miss Kimbrough, you kind of opened the door. She's now getting into settlement negotiations. I'll hear evidence, but I'm just telling you, you can cut it down, because I'm not going to give him, and I am going to make him come here to get to know her. And for a visit or two, Mom's going to be able to be there, or somebody that the child knows. You wouldn't just send the child off with somebody she'd never met before till she got to know him.
Would you like for the opposing party and I to perhaps briefly discuss this to figure out if we can reach some sort of agreement now, and then we could bring this to you? Would that work best for the court's time?
It's up to you. If you want to talk, you're here. You announced for an hour. I've got an hour. If you want to put on the evidence, I'll do that. And I'm happy to hear it. But
yes, Your Honor, if we could be briefly recalled for about 15 minutes, that would be wonderful.
Ms. Bowman, do you want to talk to Ms. Kimbrough, or do you want to proceed with the hearing?
I'm sorry.
Do you want to just go have a little conference with Ms. Kimbrough and or Mr. Bowman to see if y'all can reach an agreement based on what I've said, or do you want to proceed with the evidence right now?
I'm willing to talk. I'm just trying to do what's best for her, and I'm willing, if we can come up with something, I'm willing to talk. Yes.
Okay, great. All right. So, Ms. Chambers, why don't you send everybody to Ms. Kimbrough? You want Mr. Bowman in a breakout room as well?
Yes, Your Honor, that would be great.
All right. I'm going to send you all to the breakout room. I'm going to give you all 10 or 15 minutes to talk. After that, I'm going to begin evidence, only because I'm going to run out of time. Okay?
Yes, Your Honor.
Yes.
Thank you.
Right. You're going to get an invite to go to a breakout room here in just a second.